the NGOs be able to do some commercial or have some commercial activities. And it's not a precedent, rather it was some jurisprudent fatwa or ruling that the law prohibits this. But I think this is something that we need to think about, because if we are serious that these NGOs in Egypt would be financially financially sustainable and being independent and autonomous or independent from the foreign funding. So they need to have some their assets, some shares, and to be owning and managing projects. The issue of non-profitability is what matters, meaning that it will not be dividends divided to anyone, but to be re-pumped or re-injected in the whole system. But so it's to the contrary, in fact. Is there anybody who would feel bad if someone donates some cash? We know people are now donating cash, but what if some person donates some of his shares or some lucrative enterprise? Or what if the NGO is holding shares in one of the lucrative enterprises? The exemptions in the current law need to be there, including the tax exemptions, because these non-governmental organizations or civil society organizations shall not be incurring any taxes, because taxes are to be spent on the community and they are working for the community. Also, in relation to how the governance of CSOs, in fact, this is something that needs to be liberalized in some way. And there is no problem of having some comparability between CSOs on the one hand and the corporates on the other hand, and the NGOs and the corporates on the other hand. So the corporates are under the supervision of the state, they pay taxes. So NGOs are under supervision, like but when it comes to corporates, they are under supervision and control, but without inhibiting them from work. So I'm trying to draw a simile between the NGOs on the one hand and the corporates on the other hand, or the companies. The issue of sending the notification to the ministry first of the nominees who would be in the board members of the NGOs, and in case of no objection, they are allowed. But in fact, in companies, it is vice versa. If people are not having any criminal record, they have the right to be member in any board in any corporate. So this is the difference between this and that. Another thing, as I'm telling you, when it comes to the administrative simplification, there are so many things that can be alleviated without causing problem, without alleviating the control of the state. Like, for example, the election of the board of directors, the change of the premises, the election of the board members, having the premises, joint premises of several NGOs in the one headquarters. And this is really needed, because in many cases, NGOs each NGO need just only one room in a building with the specific people, like the accountant, the director, maybe more than one room. But what I mean is that to have a separate standalone building for each NGO, this is not a necessity all the time, particularly if it's a civil society work. So what is the problem if there is a CSR in a company that would allow a specific NGO to be inside the premises of the company? Or maybe in the remote areas, a group of CSOs collaborate and work together in order to share the cost of a premises, so they share it. So the state demand that it's a place to be inspected with the bookkeeping. This is an ability to inspect the books and examine their ledgers. This is something that's okay. There is no problem with this. In fact, this is not a very risky, thorny issue that would hinder the work of an NGO. But these are small bits and pieces that cause resources and time and appointments and several things to be paid on things other than the community, which is supposed to be the place where expenditures are made on the part of the NGO. Well, in relation to the financial dimensions, and as I told you before, the foreign funding is important, but it is not the only or the most important standard for judging this law or measuring whether it's good or not. But here there is some sort of something that we find in this law, and we need to speak about. The domestic funding or local funding is different from the foreign funding. The local funding shall not be under any restriction as long as the source is known. So, as an NGO or a CSO, we shall be obliged to know the source of each penny that we receive in a specific disclosure in the proper manner. So, in the current legislation, there is that cash donation shall not be used unless the amount is less than 10,000. Otherwise, it shall be through a check or a bank account. Also, the issue of having an auditor for the NGO in case its portfolio is above a specific threshold. But where the problem stems from? Two things. Even in local funding, there is a differentiation between receiving money and fundraising, or receiving donations and fundraising. Receiving money meaning that I was just on my desk and somebody knocked my door. I like your work. Hey, I want to pay 5,000 in cash or 50,000 through a check, and this does not need any approval whatsoever. But if the NGO would proactively work to get some fundraising or mobilize some fund, this would need an approval. There is no problem to have some supervision, but to be with notification and with simplified approaches. So just they notify, they send proper documents, and afterwards they shall be subject to auditing, but not to be at the control of a way that would hinder the fundraising activities of an NGO. When it comes to the already media known and internationally known problem, which is the foreign funding for CSOs and NGOs, I think we need to refer back to the principle that has been applicable by the Ministry of Social Solidarity before the current law, which is that foreign funding shall be provided upon a previous request, and it needs to be annexed with specific disclosures and documentation within a reasonable period of time. I think that 30 days would be a reasonable time for this. And if the authority, the relevant competent authority, rejected within the 30 days, its silence would be considered a consent, and this prompts them to use such 30 days. And it is an objection. An objection needs to be written, reasoned with, or grounded, and shall be by virtue of the stipulations of the law. But this does not carry any prejudice to the state's control and supervision and oversight over the foreign funding, because no one in Egypt would call for foreign funding not to be under any sort of monitoring, follow-up, or supervision. This is not reasonable, logical, and it's not there in any part of the world. But we had been in a balance before the current law, but we had retreated, unfortunately, because of the current text. So if we are to legalize the previously legalized situation, which is that a request shall be submitted, shall be approved within a specific deadline, else or otherwise it will be considered a consent, and the rejection or objection shall be grounded in writing. And I think this would solve the problem of the foreign funding in a radical way. And for the fourth, fifth time, and I'm so sorry for repeating myself, but the foreign funding is not the only problem with the current piece of legislation. Rather, it is relevant to 40,000 something NGOs, and not all of these are receiving foreign funding, and not all of them are concerned with this. They want to work on their daily activities with much more concern. So these problems that I have talked about, I hope that they are they are considered even if there is no decision about them. Also, what we call the interim entities or temporary entities. The state shall not be afraid of this. I mean that it does not, for example, people, if they want to have a campaign, just a campaign for some sports activity within 2 weeks for fundraising for a specific hospital, or maybe a campaign, a 1 month campaign in one of the universities for blood donation. So such kind of campaigns, temporary campaigns, this is something that's known all over the world, and it does not entail the establishment of a legal entity. However, when it is not to make it messy and chaotic, there is a need to notify the competent authorities, and within a specific specific activity that's under the applicable laws within all the thresholds and all the terms and conditions stipulated under the law. But it would be just a temporary activity 1 month or another, so there is no need to handicap it with the very costly institutional hurdles. And this does not carry any prejudice or opposition to the state oversight, because at the end of the day, the state would receive a notification represented in its line ministry about everything, the timelines, and who is responsible, who are the people shouldering the responsibility, and to be accountable before the formal authorities without hurdling the whole thing in the what we call institutional procedures, or liquidating such temporary entity after 1 week or another, or month or another. All these things are there in the different pieces of the legislation, and they are there, like the inclusion and integration systems, the voluntary dissolution, also the work with the international non-governmental organizations. But in relation to the IGOs, it is approval, not notification, and it's much more control and oversight. The last thing that I want to say in my presentation is that we need to refer to a principle which is applicable in several pieces of legislation, which is that the NGO piece of law in principle shall not have any freedom restricting punishments and penalties. Not only punishments, there are also what's called measures, administrative measures, and the law differentiates between the administrative deterrent and the criminal deterrent. The administrative deterrent is the Ministry of Solidarity, where they can stop, suspend, or do something. But the criminal deterrent is the fine or fining or confiscation of forfeiture of assets. But do you imagine that if some person abuses or misuses an NGO for espionage or for terrorist activities, or embezzled the money of an NGO, does this mean that all these shall not be under non-freedom restriction? Punishments? No, of course not. This is not what I'm saying. What I'm saying is that there is a law that's already regulating these aspects. Embezzlement is there. We have the penal code. We have the criminal procedure law, which is against the squandering of public funds and the embezzlement and all these kind of offenses. But and there are life sentences, and there are capital sentences in terrorism offenses or convictions, and there are similar convictions for those who are involved in or conspire in espionage. But when it comes to the NGO, it has nothing to do with this. So if some person manipulates an NGO for terrorism, they will be held accountable before the terrorist act or terrorism act, not before the NGO act, else it will be dual tax on the same offense. But the NGO law needs to regulate the collective work of the CSO. If they are mistaken or if they violate the law of the NGO in managing their own situation, they shall be warned verbally if it's a minor breach, and maybe they are suspended for some time or fully suspended, or the money, in some flagrant cases, the money would be confiscated. But if it's used for a crime which is really impacting another, or which is already framed in another piece of legislation, we shall refer to that piece of legislation which is relevant or pertaining to it. The confiscation and the violation needs to be done. Is it done inadvertently or knowingly, purposefully? Because maybe, for example, somebody may knock the door and say, we are building a clinic, pay 5,000, I pay 5,000 out of the budget of the NGO. What then? Is the money to be confiscated for the state in this case, or shall it be confiscated and then go back to the donator, the donor of the money? Because in this case, if I'm donating the money, what I would like is that to get my money back or send it to the clinic or the activity that I wanted to donate in. So what I mean at the end of the day, beside all these details, is that freedom restricting penalties shall not be in NGOs; it shall be elsewhere. It belongs belongs and fits elsewhere in different pieces of legislation. Just what I'm saying is that it's my efforts. I'm not wearing any hats. I just represent myself. And I found that this is a lurking opportunity for a debate that would be there with the Ministry of Social Solidarity. And I consider that it is the responsibility of all of us not to be only responsive, reactive, or passively receiving, but to be proactively working. And this necessitates that we all have the appetite to get into such discussion, not to get to a specific piece of legislation, but to achieve the optimum that we can achieve out of the already existing in the scene. Thank you so much. Thank you so much, Dr. Ziad. Before giving the floor to Dr. Hussam, I'd like to abuse my being the moderator of the session. I'll take advantage of it. The law is good, and the focus on the flexibility, and the principle is permissibility, not the opposite, because the civil society is a complementary dimension to the other institution, and it is the spirit of the law, and the return to some texts that we had before. All these are nice things, but just I want to add something. There is a theory which is called the peak theory. If you know this, we may have so many problems, and when you add on just one thing, so then you have your dream to end this very last bad thing, and we keep the piles of bad things that were before. So the issue is that we will work on the legacy, not only on the last thing, on the last bad thing in this law, or the last piece of this law which is defective. We need to work on the accumulation. I don't want to explain anymore. It's called the pig. About the pigs, it is sometimes it's a dirty, filthy house. Some person had a very dirty house. He wanted to make it clean. Somebody gave him a pig to live with him. So he said, no, 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 I just don't want the pig, and I'll be okay. And when the pig is taken out of the house, he was so happy, despite still filthy and nasty. So there are catastrophes. And most of these would be, in fact, pertaining to the executive regulation, and the executive regulations are not to be referred to or under the approval of the parliament. It shall be, the power is delegated to the ministries, so we'll have another problem. One of the things, in fact, is all the financial budgets that we have. The Ministry of Social Solidarity do not believe in our budget documents. They do not suffice with any computerized forms. They need handwriting all the time in bookkeeping, manual books kept. So we need some sort of institutional reform within the system itself, so that it would keep pace with what's new. We cannot be speaking about digital economy, taking it seriously throughout the Republic, and still we are speaking about a piece of paper and a paper taken out of a block note and things like this. It's unbecoming. So this is a really important point. The issue of signatures, the trustee and the delegation, or the secretary of the fund. Also, in relation to or the treasurer. Also, in relation to the security approval, in the last piece of legislation, there was some sort of a security war council that has been established. We will not have it. So, who are the components of such a kind of apparatus? What is the meaning of national security? This is a problem, in fact, because even in the tendering and bidding law, on all the laws, you are saying grounded rejection or objection. They would say, for security grounds. What kind of security grounds you're talking about? Of course, there are things we do not speak about, but there are things we need at least to have a line of demarcation around it, not to be used as a pretext where it's really irrelevant. So these were the couple of points that I felt like nagging me, so I wanted to say them. Just I want to say some other idea that, and I hope that it wouldn't be only amendment of the text or provisions, but to be some sort of alternative idea to be presented. part of the problem that we have in this country is the belief that the oversight over the NGOs is starts and ends by the state or in the state. So it's the state only that's having this oversight and follow-up and monitoring. Yes, the state has that right, but in companies, in corporates, the first supervisor, the first monitor, the first body to have oversight, it is the shareholder. So it is them. So when things are escalated, when it's problematic, when disputes occur, when the courts have a role to play because of litigation issues, here comes the sovereign role of the state. For the NGOs, yes, we don't have shareholders or stakeholders, but still we have very important parties. First, we have the members, people who connected their names and reputation to this to specific NGOs. I'm not a member here. In fact, you rejected my being a member in this center. In fact, I'm joking. So I do not want to be in any NGO, and then tomorrow I know that there are some pervert people. No, nobody wants his name to be connected to attributors to something like this. The other thing is the people who donate, the donors, and these are the most important side. We consider that these are people who are not given any due concern whatsoever. It's just sources of money, and they never pay heed to what's done by this money. And the third party is the beneficiary, the community. Why I'm saying this? Because what I'm suggesting is that not only to have electronic bookkeeping, but also, yes, we want to reduce the iron fist of the state or the over control of the state over the NGOs, but we need this to be made up or compensated by what's called a disclosure. We need to have a very robust and rigorous disclosure system. So when people are donating, for a specific hospital in Asyut, for example, I would say, yes, what's your website? I'll go navigate the website, not only for the address and the members of the members of the board or the board directors, the donations, and most importantly, how much they spent on their own internal activities and on the activities they do. So the most important thing for anybody who's asking for donation is the provision called financial administrative expenses, its ratio to the overall budget. If they are getting, for example, 500 and they are spending on themselves 300 as administrative or salaries and 200 on the activities, this is not illegal. But if they are only paying 100 for the administrative and the rest for the community, I will pay for the ones who are giving the lion's share to the community. This is in fact much more important than the oversight of the state. It will be very similar to the shareholders. It will be people who are attentive and keeping an eye every day every day looking at what's being done by an NGO, whether members, whether beneficiaries, whether donors, because everybody would ask, you are saying you're doing this, why are not doing it? So this is the kind of supervision we're speaking about, or the monitoring we are speaking about, and the oversight. So, of course, I'd like to take this opportunity to thank the leaders of the Ministry of Social Solidarity for being with us here. I'm so happy, sir, that you are here with us. We're so happy that you are listening to us, sir. Thank you so much. We want the executive regulation of this law to be approved by the Parliament. And this has been done in other laws, not to delegate this power to the ministries. It needs to be done outside or beyond the scope of the ministry. Because what happens, in fact, sir, I didn't know that you're from the Ministry of Social Solidarity, so pardon me.